We'll be starting with the polity section from the quarterly current affairs material of forum. Now, inauguration of the new parliament building. Salient features of the new parliament building. The Lok Sabha and Rajya Sabha halls have seating capacity of 888 and 384 members respectively. The Lok Sabha hall can accommodate up to 1272 members for joint sessions. Now, symbolism. The Lok Sabha chamber has been designed in the likeness of peacock, that is the national bird, and Rajya Sabha chamber bears resemblance to lotus, that is the national flower. In the premises of Parliament, banyan tree, that is the national tree, has been planted. Now, old Parliament building. The old Parliament building was commissioned in 1927 as was designed by British architects Sir Edward Lutyens and Herbert Baker. The old Parliament building was built for seismic zone 2. Delhi has since been reclassified into zone 4. Council House is thought to be inspired from the Chausat Yogini temple in Morena, Madhya Pradesh. Now, the Parliament building is designed as a platinum rated green building demonstrating India's commitment to environmental sustainability. The building has been designed by Padma Shri architect Bimal Patel. The building has been built according to safety standards of Seismic Zone 5. Now, Indian heritage, three galleries are present, namely Sangeet Gallery, Sthapatya Gallery, that is architectural gallery, and Shilp, that is handicraft, showcasing India's rich cultural heritage. Hand-woven carpets have been brought from Bhadoli in UP, which is known as the Carpet City, now Sengol. The Prime Minister installed Sengola scepter in the new Parliament building, presented by the head of Thiruvadu, Thiruvadurai Adhinam, that is the monastery, to India's first Prime Minister. Now, historicity of the Sengol. Tamil text refers to Tengol as symbol of a just and benevolent ruler, that is in Shilapathikram. Repeated references have been made to the spectre of the Pandyas. According to the text, Pandya spectre is so synonymous with justice that it has never known to bend. The word goal refers to the device's shaft like structure. The structure was envisioned as Sengol signifies benevolence. The other side of power is punishment, which is the case of the spectre would be referred to as Kudungol. The handing over of spectre to a ruler is practice in monarchies is believed to signify just rule. In 1947, Sengol was used as a symbol of transfer of power from British on the suggestion of C. Rajagopalachari to Pandit Nehru after being asked by Lord Mountbatten. Thiruvananthapurai Adhinam Mutt of Tamil Nadu made the Sengol. Now, the Sengol was handed over to Pandit Jawaharlal Nehru by Sears on August 14, 1947, along with Patambaram, that is a silk cloth, holy water from Tanjore River, sacred ash, and boiled rice. Now, Indian heritage, we have already covered Sengol. Now, Prime Minister installed the Sengola scepter in the new Parliament building, presented by the head of Thiruvadurai Adhinam monastery to the India's first Prime Minister. The Sengol is a sacred scepter that traces its root to Chola dynasty. Sengol served as a symbol of transfer of royal power. The word Sengol is derived from Tamil word Simami, meaning righteousness, and Kol, meaning scepter. The Nandi bull at the top of the Sengol represents justice and strength. Now, Adhinams are Shaivite monastic mutts in Tamil Nadu. They have promoted Shaivite philosophy and Tamil literature. Chola, Chera, and Pandya kings patronize the major Adhinams. Now, whip. The Supreme Court has pronounced its judgment related to the split in the Shiv Sena and the usage of whip. Now, whip is a written order that party member must be present for an important vote or that they vote only in a particular way. In India, all parties can issue a whip to their members. The office of whip is mentioned neither in the constitution, nor in the rules of house, nor in the parliamentary statute. It is based on the conventions of the parliamentary government. Now, the issue arose around the question of different whips issued by Uddhav Thackeray faction and Shinde faction, that is the legislative faction and the political party faction of the same political party. Supreme Court observation: a whip interacts with the members of legislative party to communicate the directions of the political party. It held that the political party and not the legislative party which appoints the whip, and the leader of party in the house Therefore, the speaker must recognize only the whip and the leader who are duly recognized by political party. So, legislative party is not the one which appoints the leader of the party and the whip. It is the political party. Now, national party status. The Election Commission of India has revoked the national party status of three political parties and granted the status to one other party. The conditions for recognition as national party are specified in paragraph 6b of the Election Symbols, Reservation and Allotment Order of 1968. Now, benefits of getting a national party status is that the party can contest elections all over India at the same on the same symbol. They need only one person to propose a candidate's name to file nominations for election. They can have a maximum of 40 star campaigners whose travel expenses will not be counted in the account of candidate. Other parties get only 20. They get two sets of electoral rolls free of cost at the time of revision of rolls. A party with national status gets land from government to build its headquarters. Now, the Election Commission of India now recognizes only six national parties, which are BJP, INC, CPIM, AAP, AAP, BSP, and NPP. Trinamool Congress, TMC, and Nationalist Congress Party and CPI lost their national party status. Paragraph 6C, that is related to conditions for continued recognition as a national or state party, was amended in 2016. According to the amendment, if a party fails to fulfill either national or state party criteria at an election, Lok Sabha or State Assembly, it will continue to be recognized as such for the next due election. However, recognition of the status for any subsequent election would be dependent on eligibility criteria. Now, conditions for status as a national or state party. For national party, they must be recognized as state party in four or more states. In four or more states, its candidates must have polled at least 6% of the total valid votes. And in last Lok Sabha or Assembly elections, at least 4 MPs have been elected from any states in the general election to Lok Sabha or won at least 2% of the total seats in Lok Sabha from not less than 3 states. Now, state party, they should secure at least 6% of the valid votes and at least 2 seats in assembly election, secure at least 6% of the valid votes and win at least 1 seat in the general election to Lok Sabha, or win at least 3% of the total seats or at least 3 seats, whichever is more, in assembly elections, and win at least 1 out of every 25 seats from a state in Lok Sabha general election, or secure at least 8% of the total valid votes in assembly or Lok Sabha elections. Now, control of administrative services in National Capital of Territory, Delhi, Supreme Court judgment. The Supreme Court has ruled that elected government of Delhi has control over the administrative services in National Capital of Territory of Delhi. Now, Article 239 AA of the Constitution granted special status to Delhi in 1991 through 69th Constitutional Amendment Act. The 69th Constitutional Amendment Act provided Delhi with the Legislative Assembly and a Council of Ministers. The Council of Ministers was made responsible to the Legislative and Assembly and empowered to deal with matters listed in state and concurrent list except law and order, police and land. The National Capital of Territory of Delhi Amendment Act of 2001. The Act amended the NCT Act of 1991 to give more powers to Lieutenant Governor. The term government referred in any law made by the Legislative Assembly will imply LG. It prohibited the Legislative Assembly from making any rules to enable itself to consider matters of day-to-day administration of the NCT of Delhi. The amendment added that on certain matters as specified by LG, his opinion must be obtained before taking any executive action on the decision of Minister or Council of Ministers. Now, Keshwananda Bharati judgment and the basic structure doctrine. 2023 celebrated 50th anniversary of the landmark judgment in the Keshwananda Bharati versus State of Kerala case. In 1970, Swami Keshwananda Bharati challenged the Land Reforms Act of the Government of Kerala that imposed certain restrictions on the management of land owned by Ednir Mutt. A petition was filed that the Land Reforms Act violated Article 26 of the Constitution that allowed acquisition of property and its administration by religious dominations. The case was adjudicated by 13 judge constitutional bench of Supreme Court. The decision was made by 7:6 majority. The case led to the establishment of the basic structure doctrine. Now, continuous evaluation evolution of the basic structure. In 1973, secular character of the constitution, separation of power between legislature and executive and judiciary, federal characters of the constitution were demarcated as basic structure. In Indira Gandhi versus Raj Narayan 1975, rule of law, free and fair elections, and judicial review were demarcated as such. In Minerva Wills versus Union of India, limited power of the government to amend the constitution and judicial review again. Harmony and balance between fundamental rights and directive principles. L. Chandra Kumar versus Union of India 1997, powers of High Court under Article 226 and 227. I.R. Coelho versus State of Tamil Nadu 2007, rule of law, separation of power, principles underlying fundamental rights, judicial review, and principles of equality. In Nalsa versus Union of India case 2014, Article 14 and right to equality were demarcated as basic structure. Now, independence of district judiciary, part of basic structure. The Supreme Court has held that the independence of district judiciary is part of the basic structure. Now, Aadhaar authentication by private entities. The Ministry of Electronics and Information Technology has proposed a new set of rules that would allow private entities to carry out Aadhaar authentication. At present, only government ministries and departments are permitted to undertake Aadhaar authentication for various central and state government schemes. In 2019, the government amended the Aadhaar Targeted Delivery of Financial and Other Subsidies, Benefits and Services Act of 2016, under which it allowed only banking and telecom companies to carry out such authentications for KYC requirements. The proposed new amendment will allow other entities to carry out Aadhaar authentication after getting due approval from UAIDAI. Now, defining rural and urban areas in India, the Economic Advisory Council to PM has suggested tweaking the definition of rural urban areas and establishing a trigger mechanism to allow automatic transition from rural to urban settlements after prescribed threshold is reached. The present classification of rural and urban settlements is based on the criteria that any area not classified as urban is automatically labeled as rural. Now, urban settlements are further categorized into two types: administratively urban settlements and census urban settlements. Administratively urban settlements are which are governed by urban local bodies, and census urban settlements are defined by population exceeding 5,000, with 75% of the male population engaged in non-agricultural activities and a population density of 400 people per square kilometer. Now, drug regulatory regime in India. Incidents of death of patients caused by drug manufactured in India have damaged the reputation of India as well as the pharmacy of the world. The incident indicated regulatory gaps related to the pharma sector. Now, drug regulatory regime in India. Drugs and Cosmetics Act of 1940 and rules provides the statutory framework. Central Drug Standard Control Organization is the primary regulatory body for manufacture, sale, and distribution of drugs, and it conducts periodic inspections of drug manufacturing facilities, ensure compliance with good manufacturing practices, that is GMP. Now, Drug Controller General of India is responsible for approving new drugs and monitoring their safety and efficacy. Drug Price Control Order. It regulates the price of certain essential drugs to ensure affordability to the public. State drug regulatory authorities are statutory bodies created under the Drug and Cosmetics Act of 1940. Now, exported drugs. Foreign Trade Development and Regulation Act 1992 provides the framework along with Drug Act 1940. The Central Drug Standard Control Organization issues certificates of pharmaceutical products to ensure compliance to quality, safety, and efficacy standards of importing countries. It regulates the labeling, packaging, and transportation of drugs exported from India. Directorate General of Foreign Trade issues guidance including the requirement of obtaining necessary licenses, permits, and certificates and import-export codes. Export Inspection Council ensures that the product notified under the Export Quality Control and Inspection Act of 1963 are meet the quality requirements of importing countries. Now, general consent to CBI. The Tamil Nadu government recently revoked the general consent given to CBI for conducting investigations in the state without obtaining prior permission from the state authorities. Now, general consent is normally given by the states to help CBI in seamless investigation, meaning CBI doesn't require permission from state government before starting an investigation in that state. Now, legal provisions. CBI is governed by the Delhi State Special Police Establishment Act of 1964. The CBI has unlimited jurisdiction over union territories and railway areas under this act. Section 6 of this act puts the condition of consent of the state government to investigate any case in the states. A consent to CBI can be either case specific or general. If a state doesn't give general consent to CBI, it will have to apply to the state government in every case and before taking even small actions. The Supreme Court and High Court possess the authority to direct a CBI investigation and oversee its progress without requiring the consent of the state. Now, some reports and indices. India Justice Report. This report is released by Tata Trust along with various civil society organizations like the Center for Social Justice, Daksh, Vidhi Center for Legal Policy, etc. Now, the remarks are vacancies are there in all high courts except for Sikkim High Court, which does not have any vacancy. Telangana police have bagged the top rank among the states with population over 10 million, while West Bengal has come in last. Now, World Press Freedom Index. It is released by Reporters Without Borders, which is an international NGO headquarters in Paris. It has 5 indicators, that is the political context, legal framework, economic context, socio-cultural context, and security. Norway is ranked first, and India has been ranked 161 out of 180 countries. Except for Bangladesh, Myanmar, and China, all other neighbors have a better rank than India. Now, Grievance Redressal Assessment and Index (GRI). It is released by Department of Administrative Reforms and Public Grievance, that is DRAP, under Ministry of Personnel, Public Grievance and Pensions. The index is based on 4 key parameters, that is efficiency, feedback, domain, organizational commitment, divided into 12 indicators. Panchayat Development Index is released by Ministry of Panchayati Raj. Panchayats are categorized into 4 grades based on their score. Global Terrorism Index is released by Institute for Economics and Peace. Afghanistan remains the country most impacted by terrorism for the last 4 consecutive years. India has been ranked 13th on the index. Now, some to the point. Principle of natural justice. These are basic rules that aim at bringing fairness in the procedure followed by every judicial, quasi-judicial, and administrative agencies in taking decisions. It requires the fulfillment of 3 conditions, that is, no one should be a judge in their own case. A judge should always hear the other party before giving any order. A judge should act without any bias. Now, forum shopping refers to the practice of deliberately choosing a specific court or judge for a legal case in hope of getting a favorable outcome. In Chetak Construction Limited versus Om Prakash case 1988, the Supreme Court held a litigant cannot be permitted a choice of forum and that every attempt at forum shopping must be crushed with heavy hand. Use of power granted to Supreme Court under Article 142. The Supreme Court has held that it can grant divorce under Article 142 of the Constitution in case where the marriage has irretrievably broken down. Article 142 provides unique power to Supreme Court to do complete justice between the parties where at times the law or statute may not provide a remedy. In those situations, the court can extend itself to put an end to the dispute in a manner that would fit the facts of the case. The right to change the name is a fundamental right. The High Court of Delhi and the Allahabad High Court recently ruled that right to change one's name or surname falls under the ambit of Article 21, that is right to life. Now, Commission for Railway Safety, it's a statutory body under the Railway Act of 1989, headquartered in Lucknow, Uttar Pradesh. It is under the administrative control of Ministry of Civil Aviation. Now, the CRS does not report to Ministry of Railways. CRS deals with matters related to safety of railway travels operations, among some other statutory functions mentioned under the Railway Act of 1989. Now, narco test, a drug called sodium fentanyl is injected into the body of the accused, which transports them to a hypnotic or sedated state. In this hypnotic state, the accused is understood to be incapable of lying and is expected to divulge information that is true. Supreme Court observation on the test in Selvi versus other and State of Karnataka and another case 2010. The Supreme Court held that no lie detector test should be administered except on the consent of the accused. While conducting the narco test, the guidelines of administration of polygraph test on the accused, published by National Human Rights Commission in 2000, must be strictly followed. Now, e-governed state, Kerala has become the first state in India to be fully e-governed. Now, Namsai declaration pertains to a 51-year-old interstate boundary dispute between Arunachal Pradesh and Assam. The dispute in question is over 123 villages that stretch across 12 districts of Arunachal Pradesh and 8 districts of Assam. Declaration in July 2022 resolved disputes over 37 villages, while new MOU has settled dispute over 34 villages. Now, other land disputes are between Himachal Pradesh and Uttarakhand, 6 places in the Dehradun district. Bihar and UP boundaries fluctuating due to river changing course. Arunachal Pradesh and Assam claims territory in Assam on basis of history. Assam and Nagaland. Nagaland claims 5,000 square miles in Assam on historical grounds. Odisha and West Bengal, 5 villages in Balasore, Mayurbhanj district, Odisha. Now, Odisha and Jharkhand, 7 villages in Mayurbhanj and Keonjhar district. Odisha and Chhattisgarh, 3 villages in Naupada district. Odisha and Andhra Pradesh, 63 villages in Odisha. Karnataka and Kerala, Kasargod district currently in Kerala. Now, Karnataka and Maharashtra, Marathi speaking border areas as well as Belgaum in Karnataka. So, these are the states with no boundary disputes. They are Jammu and Kashmir and Ladakh, Punjab, Haryana, Madhya Pradesh, Andhra Pradesh, Telangana, Tamil Nadu, Manipur, Mizoram, Tripura, Meghalaya, Sikkim. All other states are involved in border disputes. Now, Media One judgment in 2020, Media One TV faced a 48-hour ban following the objections from Ministry of Information and Broadcasting regarding its coverage on Delhi violence. The ministry asserted that the challenged has breached the provisions outlined in the Cable Television Network Rules of 1994. The Supreme Court has underlined that government is not equal to nation, hence criticism of government policy is not criticism of the nation. That'll be all for this video.